Under the statute of frauds, land contracts aren't enforceable unless the contract's terms are established in a writing signed by the party to be charged with performance. Waddle v. Elrod examined the types of land contracts subject to the statute of frauds requirements. In January of 2007, Regent Investments 1, LLC, sued Earline Waddle and her niece, Lorene Elrod, in Tennessee State Court. Regent alleged that it had contracted with Waddle to purchase property, unaware that Waddle had already conveyed half of her property interest to Elrod by a quitclaim deed executed in 2001. Regent sought specific performance of the contract and asked the court to set aside the deed from Waddle to Elrod, claiming that Elrod had exercised undue influence over Waddle to wrongfully obtain the property interest. Waddle filed a cross-claim against Elrod, also alleging undue influence and asking the court to set aside the deed. Waddle's cross-claim included the legal description of the property. Regent subsequently agreed to dismiss its claims, and the court scheduled Waddle's cross-claim against Elrod for trial. The day before trial, Elrod's attorney told Waddle's attorney that Elrod wanted to settle and was willing to return the half interest in the property to Waddle. Waddle agreed. The attorneys for Waddle and Elrod exchanged emails confirming the terms of the settlement agreement, including that Elrod would deed her property interest back to Waddle. After learning of the settlement, the court canceled the trial. 3 weeks later, Elrod changed her mind and refused to sign the settlement documents. Waddle moved for enforcement of the settlement agreement, but Elrod claimed that the agreement wasn't enforceable under the statute of frauds because it involved a transfer of an interest in real property and wasn't evidenced by a signed writing. In response, Waddle argued that Elrod's attorney's email, which confirmed the settlement terms and included his typewritten name, was a sufficient signed writing for statute of frauds purposes. The trial court entered an order enforcing the settlement agreement. The appellate court affirmed, holding that the statute of frauds applied only to contracts for the sale of land and not to agreements merely requiring the transfer of an interest in real property. Elrod appealed to the Tennessee Supreme Court.